Hey guys, so I'm using a new recording thing because my trial on the old one expired, so it's a little bit different. So if I make a mistake with the video, I apologize. I can apparently now record my screen, which is really nice. Um, anyway, so two major things happened yesterday. Actually, a lot of major things happened, but I'm going to focus on the DOMA and Prop 8 decision. And I'm actually going to make a lot of videos on this. So the way this is going to work is I'm going to make a video for the opinion of the court in Windsor, which is the DOMA case, a video for each of the dissenting opinions, a video for the opinion of the court in Hollingsworth versus Perry, and for the one dissent there. And then I hope to have time to make another video for the next step in validating or overturning Section 2 of DOMA and um, responses to the opponents of the court decisions. Sorry, I'm stumbling a little. Um, okay, so this video is going to be the opinion of the court in Windsor versus the United States. And I've already read over the opinion of the court. I have it up in my browser, and I will be going over it as I go. And in fact, what I'm going to do now that I can record screen, nah, I'm not going to do that. That'll bore you. Okay, I might do it occasionally. So the beginning is basically the briefing of the case. It says this is, U.S. versus Windsor. Windsor's the executor of the state, estate of Spire, which is her wife. So these two, Edith Windsor and Thea Spire, got married in Ontario, Canada, back in 2007. And shortly thereafter, New York started allowing same-sex marriage. I believe at the time New York recognized marriages performed in other states and countries, but did not issue marriage licenses itself. So Spire died in 2009, leaving her estate to Windsor, her wife, and Windsor wanted to claim the federal estate tax exemption, which is just, if you're a spouse, you don't have to pay the estate tax on your spouse's stuff because that's your spouse, and you have to survive off their remaining stuff. The idea is, anyway. Um, and it's at least half yours, a lot of it. So, anyway, the estate is left to Windsor, and the IRS is like, excuse you, you have to pay the estate tax, and Windsor's like, we're married, we don't need to do that. And the IRS is like, no, you really do. So Windsor takes them to court saying that the Defense of Marriage Act violates equal protection in the Fifth Amendment, and the Attorney General, the Obama administration, directed the Department of Justice not to defend, which is not completely unprecedented. Reagan, both Bushes, and Clinton have all refused to defend cases before the Supreme Court in the past, with varying degrees of success as far as the court deciding to hear the case. And a lot of times it doesn't go well for the executive branch when they refuse to defend. Anyway, the Obama administration refused to defend, but they continued to enforce the act because Obama said the executive branch doesn't decide the constitutionality of the law. Ultimately, the Supreme Court does that. My job is to execute, to carry out the law, and this is the law, I'm going to carry it out. But I don't believe it's constitutional. I'm not going to defend something I don't believe. So the Congress got together and they said the administration's not going to defend it, the Department of Justice isn't going to defend it, we'll defend it. So they appointed the bipartisan legal advisory group to defend this case. And so it went to the district court first, and the district court held that Section 3, which is what's in question here, DOMA, which denies federal benefits to same-sex couples who are legally married in the state in which they reside, they ruled that Section 3 was unconstitutional. Flagg appealed to the appeal circuit. So the Second Circuit of Appeals heard the case, and they upheld the district court's ruling. So Flagg again appealed to the Supreme Court, and this is where it becomes a Supreme Court national issue. So the court overturned Section 3 of DOMA, noting that Section 2 was not challenged and therefore it could not rule on that. Section 2 is what states that the states are allowed to not recognize a marriage that performed in another state. So like someone married in New York moves to North Carolina doesn't have to acknowledge it under Section 2. They noted Section 2 was not challenged. This could bring about some awkward and semi-problematic conflicts in the sense that if the federal government has to recognize it and they move, are they still recognized under federal statutes but not under the new state statutes, or is it just gone altogether? How does that work? That's going to be a sticky issue. The courts are going to have to work that out, which means Section 2 will probably ultimately come before the Supreme Court within the next couple of years. In the meantime, it's just going to be a sticky issue that the courts are going to have to decide. And so, yeah, moving on, the court, decided to consider whether or not they could hear the case. We're going to move on from the little introductory. If you would like to read the little introductory summary, basically, that's cool. So the opinion of the court is written by Justice Kennedy, and Kennedy was joined by Ginsburg, Breyer, Sotomayor, and Kagan. Roberts led the dissent, along with Scalia, Thomas, and Alito. No surprise there. The conservative justices dissented. The more liberal justices upheld. It's normal. So Kennedy, as the kind of swing voter, even though he wasn't a swing voter, but as more of a swing voter than the other four, writes the decision. This is also normal court. I almost want to say court politics. That's not politically correct, but it is basically the case. Usually the swing voter gets to write the opinion. And in that case, Kennedy is considered more of a swing voter. So I'm going to read you the little paragraph that comes before the sections start because it sums up the case well. So this is Kennedy's writing. Two women, then resident in New York, were married in a lawful ceremony in Ontario, Canada in 2007. Edith Windsor and Thea Spire returned to their home in New York City. When Spire died in 2009, she left her entire estate to Windsor. Windsor sought to claim estate tax exemption for surviving spouses. She was barred from doing so, however, by a federal law, the Defense of Marriage Act, which excludes same-sex partners from the definition of spouse, as that term is used in federal statutes. Windsor paid the taxes but filed suit to challenge the constitutionality of the provision. The United States District Court and the Court of Appeals ruled that this portion of the statute is unconstitutional and ordered the U.S. to pay Windsor a refund. This court granted certiorari and now affirms the judgment in Windsor's favor. And I totally said that wrong, even though it's the correct Latin pronunciation. I don't think it's the correct legal pronunciation. Anyway. So section 1 kind of deals with the history, okay, so it says states were beginning to consider same-sex marriage, and before any of them permitted it. Congress enacted the Defense of Marriage Act, and the Defense of Marriage Act basically, it notes right here, Section 2, which has not been challenged here, allows states to refuse to recognize same-sex marriages and under the laws of other states. See 28 U.S.C. Section 1738C, which we're not going to give reference right this second because most of you don't want to. Section 3 is at issue here. Okay. Section 3 amends the Dictionary Act of the United States Code. This is Title I, Section 7, providing a federal definition of marriage and spouse. So here's the direct quote from Section 3 of the Defense of Marriage Act. In determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or wife. End quote. So what's being said here is, well, pretty obvious. I'm not going to say it again. Anyway, so the definition does not forbid states, but it says the federal government doesn't recognize it. We don't give you federal marriage exemptions and such for it. So the idea, which is also noted, was to discourage states from recognizing it. It didn't work very well. There's a little bit of history on Windsor and Spire's relationship, the amount of the estate tax. So, the filing of the lawsuit. And then we get to the more interesting bits, where they're defining whether or not these people have legal status. Do the parties in the case have legal status? And this is important because if they don't, the case is invalid and it gets thrown out. So Flagg can't defend, the case is thrown out. If Windsor isn't allowed to prosecute, the case is thrown out. What this means is there has to be injury to both parties, okay? There has to be vested interest in injury. A straight couple, a straight male in a committed heterosexual marriage could not have prosecuted this. Why? Why could he have not been in the prosecution? And by prosecuted this, I mean that he couldn't be the aggrieved party. He couldn't be the originator of the suit. He couldn't have replaced Windsor because there's no injury done to him. There's no grievance done to him. So in order to determine whether or not they can hear the case, they have to determine, do they have legal standing? Are they allowed to bring this suit? Is either side not really injured by this? So basically, the majority determined that both sides have a vested interest in bringing this case. They're both hurt if they don't bring the case. So this is section 2, by the way. So they begin with saying Windsor is definitely justified under Hine versus Freedom from Religion Foundation, Inc., which states that a taxpayer has standing to challenge the collection of a specific tax assessment as unconstitutional. Being forced to pay such a tax causes a real and immediate economic injury to the individual taxpayer. End quote. So that says, okay, Windsor definitely has standing. There's no if, but, maybe about that. The question mostly focused on in section 2 is, does Flagg have standing? Because generally the executive branch is supposed to defend the laws. That's part of its duties, and the executive branch declined to do so, which is not entirely unprecedented, but it is unusual. So they had to address whether Congress could defend the law. Do they have legal standing? And they ultimately decided it did. They appointed someone to argue that it did not, because Blagg, Windsor, and the executive branch all agree that Blagg had standing, but that doesn't matter. The court has to agree to it. So they appointed a lawyer to argue that Blagg did not have standing since no one else wanted to do so. So they basically ruled that under Article 3, based on previous court precedent, which said that the plaintiff must have suffered an injury, in fact, an invasion of legally protected interest, which is concrete and particularized, actual or imminent, not conjectural or hypothetical. Second, there must be a causal connection between the injury and the conduct complained of. The injury has to be fairly traceable to the challenged action of the defendant, not the result of independent action of some third party before the court. Third, it must be likely, as opposed to merely speculative, that the injury will be redressed as a favorable decision. So, this is Luja versus Defenders of Wildlife, a quote from them. So what they're saying is, we can hear this because it's directly traceable to Congress's actions. They also say they can hear it under prudential standing, which was a criterion established in Deposit Guarantee National Bank versus Roper. So basically they say, yes, Blagg can bring this case, and further, it's comparable to INS versus Chatha, where INS was allowed to defend when the executive branch did not, because the INS would suffer an injury under Chatha. In this case, they're saying the government would suffer injury because they wouldn't get the estate tax if they just let the executive branch's decision stand. They further argue that they agree with the executive branch that the executive branch cannot decide if something is unconstitutional on its own, and to do so would be to take away the power of the court granted under Marbury versus Madison of judicial review, which is one of the earliest cases in the history of the Supreme Court, which sets the precedent for the ability to rule a law unconstitutional. So they say, okay, we're allowed to hear this case. Moving on. By the way, they spend pages and pages arguing this. I'm not going to subject you to that, but just know this video is not very long compared to how long the decision is. So now they go into section 3. They go into some history of the New York state laws, and they say they're basically establishing that the state of New York enacted laws allowing same-sex marriage, and that the state of New York did so in order to promote equality, that these laws are constitutional because the state is allowed to define marriage. They're very big on states' rights in this decision, which could hurt us in this decision to overturn Section 2, because it could be cited as precedent that the state has this kind of power, not the federal government. And then it would become a question of whether or not we can force the states. There is some precedent that the 14th Amendment causes the Bill of Rights to apply to states. That would be a whole nother argument coming in a later video. Anyway, so they spend a lot of time talking about New York laws and establishing, the purpose and scope of New York laws and whether or not those are constitutional. And they say, yes, New York laws are constitutional, they're acceptable. Their purpose was to get rid of discrimination and promote equality among this group of people. And DOMA takes away the state's right. It denies the state of New York's efforts to do away with the inequality, yada, yada, yada. The recognition of civil marriages is so here they're kind of establishing that the states have the rights to make these kinds of laws to allow permit gay marriage, and that um, sorry, it's a little bit complicated and thick in this section because there's a lot of citation and stuff that most people don't really need to know. I mean, if you want to, I'm going to link this decision in the description if you would like to read it, but this is supposed to be kind of an overview summary of it. So they continue on and they argue that DOMA rejects the long-established precept that incidents, benefits, and obligations of marriage are uniform for all married couples within each state, though they may vary subject to constitutional guarantees from one state to the next. So basically they're saying the rights are the same for all married couples. These are married couples, therefore the rights are the same. The federal government isn't allowed to discriminate if the state is not discriminating. And DOMA takes away from states' rights. So we continue on. They further state that DOMA injures the state of New York's intentions with its laws. It injures the intentions to make it equal and fair and safe and to do away with discrimination. So they're like, not only is this an infringement on states' rights, it's just an infringement on rights in general, and it's the state can define this right, and the federal government can't just come in and say, yeah, you're not married according to us, but you're married according to your state. So more confirmation that of this. They go into an interesting little discussion, though, in this section, section 4, about how the Defense of Marriage Act is passed. You know, the House concluded that DOMA expresses both moral disapproval of homosexuality and moral conviction that heterosexuality better comports with traditional morality. The stated purpose of the law was to promote an interest protecting traditional moral teachings reflected in heterosexual marriage laws. And they said Blagg said the same thing. Said this is why we did it, for these moral religious purposes. And the congressional goal was to put a thumb on the scales and influence the state's decision as to how to shape its own marriage law. So they're saying not only that the government's putting pressure on them to try to prevent this thing from happening, and we don't like that. DOMA's operation confirms this purpose. DOMA frustrates the objective of getting rid of the inequality, and it goes on in that vein for a little while. And it also goes on to state, you know, this section of DOMA brings financial harm to children as same-sex couples, raises the cost of healthcare. They're determining that there are injuries due to this. They also spend some time talking about how it makes spouses of same-sex couples exempt from certain government integrity rules, and they don't like that. So their final sentence is the judgment of the Court of Appeals for the Second Circuit is affirmed. It is so ordered. So basically, federal government, you can't do this. The states are allowed to define marriage. You have to offer benefits, federal benefits, as far as taxes and laws and legal protection equal for all marriages. And if the state recognizes it as marriage, you must recognize it as marriage in that state. But they're not saying that the states have to recognize marriage from other states, which is semi-problematic. We'll get to that in a later video. What are the implications of this? Well, first and foremost, there are implications ranging in the tax and financial. That was why this suit was originally brought up. married same-sex couples may now file as married on federal tax forms. They receive the same kind of tax benefits, tax credits. They're considered married for health care issues. If they're employed at a federal agency, they're now going to be recognized with the same federal benefits as the spouse of any other married couple. There are other legal protections afforded by the federal government to marriages. The integrity rules they're now going to have to follow. I suspect many of them were already following those, but if they weren't, now they have to. So on and so on. There's also been some key court cases that have come up with immigration, where if you are legally married to someone in the U.S. and you're not from the U.S., you get U.S. citizenship by marriage. But because DOMA wouldn't let the federal government acknowledge the marriage, a same-sex couple that got married, the other person would not become a U.S. citizen and could be subjected to deportation. That is no longer the case. Same-sex couple, the spouse is considered a U.S. citizen now and cannot be deported. I'm sure this is going to bring a whole other wave of court cases from couples where the partner, spouse, has already been deported. But that's a sticky mess the court is going to have to handle, along with this distinction about states' rights that they're so stringent on in this decision, that it's a states' rights sort of judgment. And yet the federal recognition, would it transfer to a state as a federal recognition to a state where the same-sex marriage is not allowed or not? That's going to be a bunch of sticky court cases. We're going to see a lot more movement on this. Like I said, I expect there to be a case involving Section 2 shortly. In the next few years, we'll see it before the Supreme Court. I wouldn't expect anything huge to come out of that either, though. I feel that the Supreme Court will probably find a way to narrowly tailor it if the Roberts Court gets a hold of it in such a way that it has much narrower implications and it's less of a victory. Even this is less of a victory than it could have been, because they kept affirming that marriage is a state's prerogative. That's going to hurt the case against Section 2. But ultimately, this is a small victory, and the battle's starting to turn uphill, from uphill to a level playing field. Hopefully we can get a few more victories like this. Hope you enjoyed this, learned from it. I'll be going through the dissents in the next videos. And yep, see ya.